Okay, now as we are headed to ending layer 1, let's cover out plea bargaining. Write down the case law. It is Centobello versus New York 1971. So this is the case law from which the concept of plea bargaining was introduced into the United States of America, and therefore then again we got inspired. So plea bargain is given in chapter 21A, section 265A to 265L, both very important MCQs from the prelims perspective. It was inserted into the CRPC by the Criminal Law Amendment Act 2005, suggested for the first time by the Justice Malimath Committee, and the 142nd Law Commission laid down this scheme of plea bargaining, all very relevant points for the CRPC. Now the funda is, I save you time by pleading guilty, as it is courts are overburdened, right? But since I'm doing a favor to you, you will do a favor to me by lessening my sentence, the imprisonment sentence, that is. So please give me a lesser sentence, maybe a lesser fine as well. But I am plea bargaining, as in I am pleading and bargaining at the same time to you. That is the court, that my lords, I am saving you time, no need for a trial. I confess to the crime, to the offense, whatever, but only if you lessen my sentence. This is a trick, this is a concept that usually most government authorities almost always play around with very hardened criminals ki bhai bol de teri punishment kam kara dunga, theek hai ji. Now chapter 21 of plea bargaining, now write down these in bullet points, all right? So under 265A, first and foremost application of the chapter, but these are offenses in which basically you cannot apply for plea bargaining. Pointer number 1, where an imprisonment or rather punishment is of death. Pointer number 1. Pointer number 2, imprisonment is for life. Pointer number 3, imprisonment is of a term that is exceeding 7 years, all right? Or if the offense affects the socio-economic condition of the country, these offenses are usually published in the Gazette, or has been committed against a woman or a child below the age of 14 years. तो 3, 4, 5 पॉइंटर है यहाँ पे. क्या क्या है? Punishment for death, imprisonment in life, imprisonment for a term exceeding 7 years, आपका against a woman, child less than 14 years, or if the offense affects the socio-economic condition of the country, right? In all of these, you will not be able to apply for plea bargaining. Remember that. Very crucial. ठीक है जी. अच्छा, और थोड़ा सा जो essay type और वो सब अभी हम जब layer 2 layer 3 में आते हैं तब केलकर वगैरह में से निकाल लेंगे. But right now, primarily speaking, again, from the prelims perspective, a person accused of an offense may file an application for plea bargaining in the court in which such offense is dash. That is the question. So that's pending for trial. कहाँ लगाएंगे plea bargaining की application? Wherein your case is pending for trial. The application under subsection 1 shall contain a brief description of the case relating to which the application is filed, including the offense. So there has to be an affidavit sworn by the accused, pointer number 1, लिख लीजिए, stating therein that he has voluntarily preferred. So if you see the entire plea bargaining, I don't know how many times they'll focus, it has to be completely voluntarily, because remember, police is always standing there with a डंडा कि भाई ट्रायल पे क्या जाएगा, बस मान ले बात हमारी, ताकि हमारा भी केस सॉल्व आउट हो जाए, कोर्ट का भी टाइम बचे और तू अंदर बैठे. That's why confessional statements, the evidentiary value of them is 0, right? To the police, that has been the statements that have been made to the police. Why? Because we are presuming that the police has pretty much basically done this via, you can say, coercion, not completely defined by the Indian Contract Act, not completely defining, not the one under the Indian Contract Act, but you know that there is some undue influence, there is pressure, coercion in the sense कि डंडा पड़ेगा. That also is basically, the assault is prohibited by the IPC, is it not? It's an offense. So there has to be an affidavit, but the court has to check that the accused has voluntarily preferred, after understanding the nature and extent of punishment provided under the law for the offense, the plea bargaining in his case, and that he has not previously been convicted by a court in a case which had been charged with the same offense. This is one crucial detail. अभी दोबारा आते हैं इस पे, but यहाँ पे भी पॉइंटर लिख लीजिए. सो अलग अलग शर्त लग गई. अभी तक क्या क्या लगी जी? Death imprisonment for life and imprisonment where 7 years or more is the punishment. Against a woman of a child less than 14 years of age, because then, you know, if you're committing offenses against a child less than 14 years of age, आपके सिंग निकले हुए हैं, you are pretty much evil. He will not allow you to bargain in the court of law. Now, and you must have not been previously convicted by a court, by any court basically, in a case which he had been charged with the same offense. So there has to be no prior convictions for the same offense. Okay, now same offense as in ये वो वाला नहीं है, अब यहाँ पे वो मत लगा लीजिएगा कि डबल जेपर्डी लग जाएगी, सेम ऑफेंस बोला आपने, सेम ऑफेंस एज इन यू ऑलरेडी बीन कन्विक्टेड way back then or maybe 5 years ago in the same category of offense. All right, now after receiving the application under subsection 1, what shall the court do? The court shall issue notice to the public prosecutor or to the complainant of the case as the case may be, because either a case would have been lodged on आपके क्या बोलते हैं, यहाँ पे थोड़ा सॉरी मेरा हाथ लग गया, तो यहाँ पे either a case would have been lodged on a police report or the complaint. It's either a complaint case or cognizance must have been taken on a police report, right, as the case may be, and to the accused to appear on the date fixed for the case. Now let me find where my note has flown away. Now, when the public prosecutor or the complaint of the case as the case may be and the accused appear on the date fixed, the court shall examine the accused in camera. It cannot be in an open court. It has to be in the chamber of the judge, where the other party in the case shall not be present. सामने वाला नहीं आएगा, because again voluntarily होना चाहिए, कोई pressure नहीं आना चाहिए. To satisfy itself that the accused has filed the application voluntarily, पूछ लेगा ना, किसी ने डंडा मारा है, तुम ये क्या करने जा रहे हो, ट्रायल का हक है तुम्हारे पास, what exactly are you up to, right? So this is another condition. So in camera proceeding, the other party need not be present, and the magistrate or the judge sahab will check आपका the complaint was filed voluntarily. The court is satisfied that the application has been filed by the accused voluntarily. It shall provide time to the public prosecutor or the complainant of the case as the case may be, and the accused to work out a mutually satisfactory disposition of the case, which may include giving to the victim by the accused the compensation and other expenses during the case, and thereafter fix the date for further hearing of the case. भैया आपस में मिल लो. Yeah, let us say that it's a case of an accident. सामने वाला is pretty much alive, only had suffered an injury. Okay, you're plea bargaining. वो कहता है जी आप थोड़ा पैसे वैसे से सेटलमेंट अपनी केस की कर सकते हैं. माइंड यू, दिस इज डिफरेंट फ्रॉम कंपाउंडिंग ऑफेंस. दिस इज बेसिकली यू आर सेइंग कि जी मैं ये सब काम करके दे देता हूँ, बट प्लीज गिव मी अ lesser sentence. Okay. The court finds that the application has been filed involuntarily or by the accused, or he has previously been convicted by a court in a case in which he had been charged with the same offense. It shall proceed further in accordance with the provision of this code. Basically, now I need not read the entire subsection, or rather the clause. It will proceed ahead with the trial. All right. अगर ये पता चल गया that the application is involuntarily and आपका you have already been previously charged with the same offense, well, so long, no plea bargaining for you. Guidelines for mutually satisfactory disposition. In working out a mutually satisfactory disposition in a case instituted on a police report, the court shall issue notice to the public prosecutor, obviously the police officer who had investigated the case, that's the IO, the accused and the victim of the case, to participate in the meeting to work out a satisfactory disposition of the case. तो IO साहब भी होंगे, PP साहब भी होंगे, accused भी होगा, victim भी होगा, to go in for mutually satisfactory disposition of the case. Right, and again, see, provided that throughout such process of working out a satisfactory disposition of the case, it shall be the duty of the court to ensure that the entire process is completed voluntarily, so that पीछे से कोई डंडा नहीं है कि ट्रायल पे मत जाना, इतना टाइम लग जाएगा. It has to be completely voluntarily. You need to understand that you're letting go of your right for a trial, for a fair trial, and if you're letting go of such a right, then obviously the court will lessen the sentence, क्योंकि आप उनका टाइम बचा रहे हैं. करेक्ट. अच्छा जी. Then आप आए clause B में, in a cause instituted otherwise, in a case instituted otherwise than on police report, the court shall issue notice to the accused and the victim of the case to participate in a meeting. अब यहाँ पे IO साहब कैसे आएंगे? ये तो कंप्लेनेंट वाला केस है. कंप्लेंट केस के अंदर सामने वाले को बुलाओ जिसने कंप्लेंट डाली थी, और आके उससे पूछते हैं कि भाई क्या करना चाहते हो. Now report of the mutually satisfactory disposition to be submitted before the court. अब एक बार ये वाले स्टेज से हम चले गए. A satisfactory disposition of the case has been worked out. The court shall prepare a report of such disposition, which shall be signed by the preceding officer of the court and all other persons who participated in the meeting. सारे के सारे को लेकर आओ, सबके साइन कराओ. And if no such disposition has been worked out, the court shall record such observation and proceed further in accordance with the provision of the court from the stage the application under subsection 1 of 265B was filed with this case. कि जी अब ट्रायल शुरू कर लेते हैं. अगर नहीं हो रहा, म्यूचुअली सैटिस्फैक्टरी डिस्पोजिशन नहीं हो रही, कोई नहीं, प्ली बार्गेनिंग हटाओ, ट्रायल कर लेते हैं. When a satisfactory disposition of the case has been worked out under section 265D, The court shall dispose of the case in the following manner. The court shall award the compensation to the victim in accordance with the disposition, and here the parties on the quantum of the punishment, releasing of the accused on probation of good conduct or after admonition under section 360. We'll come to 360. In fact, पिछले lectures में हम 360 देख ही चुके हैं. I believe यहाँ से और कुछ करने का नहीं है. The court shall deliver judgment in terms of section 265E in the open court. अभी तक in camera proceeding चल रही थी. And the same shall be signed by the proceeding officer of the court. The judgment delivered by the court under section 265G shall be final and no appeal, mind you, no appeal except the special leave petition under 136 straight to the Supreme Court, and writ petition under 226 and 227 of the Constitution shall lie in any court against a judgment. आप अपील से तो आप चले गए प्ली बार्गेनिंग के बाद, अगर आपको अब जजमेंट नहीं पल्ले पड़ रही कि अरे बाप रे मैं कहाँ फंस गया, there is no appeal in the plea bargaining cases. Write this down, mark it somewhere. You can only file a SLB under 136 और writs लगाएंगे आप हाई कोर्ट में 226, 227. उसके अलावा you don't have any remedy against plea bargaining, because that is why we were insisting कि भाई साहब चेक कर लो voluntarily है ना, क्योंकि अब आपकी litigation से आप बाहर आ जाओगे. और फिर अब जो कोर्ट ने कह दिया, क्योंकि नेगोशिएशन के अंदर अब वो थोड़ा ना जाके बोलेंगे भाई यहाँ थोड़ा थोड़ा ठीक लगा लो, दो ले लेंगे. कोर्ट ने जो कह दिया फाइनल है. फिर एसएलपी लगा के जाना सीधा सुप्रीम कोर्ट. और वहां पे भी आर्टिकल 136 याद है कॉन्स्टिट्यूशन में, द सुप्रीम कोर्ट में और इन इट्स डिस्क्रिप्शन, कंपल्सरी थोड़ा ना कि एसएलपी सुनी जाएगी, कैन गेट डिसमिस्ड एज वेल. फंस गए. क्या करें, इसीलिए कहा था वॉलंटरली कर लो, देख लो, तभी साइन कराए थे डिस्पोजिशन पे भी. इसीलिए CRPC is actually beautiful in itself. Part of the court in plea bargaining, a court shall have for the purpose of discharging its function in the chapter all the powers vested in respect of bail, trial offences. I believe इसके अंदर से कोई MCQ नहीं है, so why not, why should we get into this? अच्छा 265I में ये चीज़ है कि आप समझ लीजिए, let us say that you have bargained for plea and you've already been inside, आपका ट्रायल नहीं शुरू हुआ, 2-3 महीने हो गए. So obviously we are, let us say, and then court pronounces let us say an imprisonment for 6 months. तो पहले वाले जो 3 महीने आपने काटे हैं वो हम उसमें से आपको डिस्काउंट करके दे देंगे, क्योंकि एक्चुअली प्ली बार्गेनिंग इज भैया ठीक लगा लो, डिस्काउंट ही है ना. अच्छा जी, एंड लेट मी जस्ट हैव अ रीड as to why I put these sections here. Statement of accused not to be used, notwithstanding anything contained in any law for the time being in force. That's a non-obstante clause. The statements of fact stated by an accused in an application for plea bargaining filed under Section 265B shall not be used for any other purpose except for the purpose of this chapter. अब ये statement आप उठा के किसी और ट्रायल में ले गए या इन्हीं के अगेंस्ट पीछे आपने यूज कर दी कि जी पहले तो ये आदमी ये बोल रहा था ईस्टॉपर लगाओ, कुछ नहीं चलेगा. प्ली बार्गेनिंग में जो कुछ बोला है वो प्ली बार्गेनिंग के पर्पज से ही रहेगा, अदरवाइज नथिंग डूइंग एक्सेप्ट फॉर दिस. ओके, नॉन एप्लीकेशन ऑफ दिस चैप्टर, नथिंग इन दिस चैप्टर शैल अप्लाई टू एनी जुवेनाइल और चाइल्ड एज डिफाइंड इन क्लॉज के ऑफ सेक्शन 2 ऑफ द जुवेनाइल जस्टिस केयर एंड प्रोटेक्शन चिल्ड्रन एक्ट 2056 ऑफ 2000. ठीक है जी, आई बिलीव दैट शुड डू द ट्रिक. ऑलराइट, नाउ सी यू इन द नेक्स्ट लेक्चर्स. आई बिलीव लाइक बेल के ऊपर बात करनी रहेगी इन लेयर 1 ऑफ आवर कोर्स, एंड उसके बाद 2-3 मिसलेनियस चीज़ें रहेंगी, एंड दैट्स अबाउट लेयर 1 तो हमारी ओवर हुई. फिर मूव ऑन टू लेयर 2, मूव ऑन टू लेयर 3 करते रहेंगे. CRPC में मास्टरी करके मतलब परेशान कर देंगे इस बैराक को. ठीक है जी, ऑलराइट, नाउ सी यू इन द नेक्स्ट वन, टेक केयर, बाय.